Hello students, let's start with our mains program student. So exam is just round the corner and at this particular juncture, my primary focus would be on to covering as many issues as possible for GS paper 2 and paper 3, which are definitely going to have many more questions related to the current affairs. And since my expertise into the topics of current issues, I'll be going to make sure that various different important current issues, their important postulates, important snippets are going to be there on your notebook, and therefore I'm starting my session for the paper 2, paper 3 current issues, which are very well going to be integrated with your overall preparations as well. So right now we have close to 60 days in our hand, and in this particular moment your primary focus would be on to at least grabbing 7-8 good handy points for any particular issue that you are reading it. Do not go beyond it, because going beyond 8, 9, 10 points or going beyond 1 or 2 pages is definitely going to make your work more bulkier. And right now at this stage you need to look into the width of the topic rather than the depth of the topic. So our main session 2025, this is going to be our session number 1, and in today's session I'll be going to start with the GS paper 2. So yeah, GS paper 2 is being broadly divided into 4 different areas, where you'll be going to have the polity issues, you'll be going to have the governance topic, issues related to social justice, and of course international relations. So my primary focus would be essentially onto the paper 2 right now. I'm going to start with the polity and constitutional topics, and 3-3-4-4 classes on each and every matter I'll be going to get it covered as much as it can be possible. So you can assume at least 13-14 classes for the paper 2 and at least 13-14 classes for the paper 3 would definitely going to summarize your preparation overall, especially for the last 8 or 9 months, whatever current issues are going to be there. You need to have a bit of information related to it. So without wasting any time, let's start with the paper 2 orientation, paper 2 learning, and especially I'm going to put my entire focus, especially right now, onto the polity and constitutional topic. So let's start with the topic number 1. So we have a very limited time, and keeping this limited time, I'm starting with the first topic, which is Waqf Amendment Act 2025 and its debate with the principles and tenets of Article 25 and Article 26. One more thing before I proceed ahead. These sessions are going to be available on your app, as well as I'll be going to make sure it is going to get it available on the YouTube as well in our Sanskriti IAS channel. And at the same time, those of you who are watching this particular video, I would request, there is one more session which I have recorded it as the strategy session for paper 2. It has already been uploaded onto our channel, and it is a bilingual introductory class. So I would request you to watch that particular class as well. There is a very well defined presentation of paper 1 and paper 2 available on that particular video. You can download it. All last 12-year questions of paper 2 are being easily available over there. I have bifurcated paper 2 into various different small topics. So you can download that particular presentation, and you can have the idea of the questions that have been asked in the past 12 years and couple of nuggets that I have already shared with you. And as far as the academics are concerned, I'm starting the topic Waqf Amendment Act 2025 versus its interlinked debate with the Article 25 to 26. So one very relevant pertinent question. On 3rd of April 2025, Government of India introduced a rechristened Waqf Amendment Bill 2025. Earlier it was introduced in the month of August 2024, but after a lot of hue and cry, government decided to create the JPC. JPC submitted its report, and in the month of April 2025, the bill has been passed from both the houses after having a good amount of discussion in the parliament as well. Now, one very important question that I am raising it over here is the Waqf Amendment Act 2025 is in contravention to the principles of Article 25 and 26. If the answer is no, then you have to definitely abide by it, and you have to give the proper reasoning for it. And if the answer is categorically yes, then again you need a proper constitutional reasoning why this supposed act is in contravention to the principles of Article 26. Right now, this matter is already been sub judice, and I guess judgment has been reserved by the Honorable Supreme Court. It's the Justice Gawai bench which is going to pronounce the judgment sooner or later related to the relevance of the Waqf Amendment Act 2025, especially its constitutional principle. And there are actually 4 major questions which have been put in front of Supreme Court bench in order to identify the merits of Waqf Amendment Act. Those 4 questions I'll be going to share with you. But as I usually do, first of all, we'll be going to look into all the important aspects of this particular act which has been there in the news. So here are going to be 3 or 4 things which I'm going to look into. First of all, I'll be going to introduce to you background or basic definition. First of all, we'll be going to look into the background of this particular act, why it has been amended in the year 2025, what are the proper reasoning for it. So first of all, we'll be going to look into the background and basic definition. What do we mean by Waqf? What do we mean by Waqf Act 1995-2013? All those different definitions, I'll be going to have a complete focus onto it. So first of all, we'll look into definition. After that, we'll be going to look into important act related to Waqf property. Our second topic is going to be this one. We'll be going to look into important act related to Waqf property. After that, especially from the year 1913, so during the time of the Britishers to till now, year 2025, what all acts were being associated with the Waqf property, we'll be going to have a look into it. Then we will look into government argument. Why need for amendment? What was the need for amending the Waqf property? What was the need for amending it? That's point number 3. Point number 4, which is going to be the important aspect of highlights of the bill, highlights of the Waqf amendment bill. And towards the end, 5th one, which is very essential from our examination perspective, it's going to be the analysis. So these are the 5 areas under which I'll be going to cover this particular topic. Now the topic is slightly lengthier because there are hell number of articles in there in the Indian Express and Hindu, and therefore we have to summarize all those articles which are essential for our exam. Of course, from the mains perspective, you are only supposed to look into the analysis, but these are the things which I cannot go away with. I have to look into this particular part as well. So let's look into this area. It's a very lengthy topic, but the learning is going to be very, very sharp. So let's look into this particular topic, student, one by one. First of all, let's look into the basic definition. Basic definition, or I would rather say introduction of the topic. So this particular word, Waqf, is being derived from the Arabic word, has been derived from the Arabic word Waqufa. Waqufa. So Waqf as a word been derived from the Arabic word Waqufa, which essentially or primarily means endowment. Endowment. And since it has its association with the Islamic religion and tradition, what do we mean by endowment over here? Endowment in Hindi means daan or dakshina. दान, अपनी प्रॉपर्टी दान में दे देना. So Waqufa primarily means endowment. Endowment by whom? Endowment by a Muslim. Endowment by a Muslim or endowment by a person who believe in the Islamic traditions and he is a Muslim, and he is donating his property for some social welfare, for some charitable work. So endowment by a Muslim for social welfare or for some charitable work. Keep on writing. If you are preparing for the exam, then only good vocabulary and good sentence structure is going to create the real difference in the examination hall. Therefore, I would suggest you to keep on writing these important points which are going to create a good difference in the examination hall itself. So, Waqf being derived from the Arabic word wakufa, which essentially means endowment by a Muslim for a social welfare or for some charitable work. And there is a legend, there is a story related to it. Let me share you one important story related to Waqf property itself. So student, there are total 5 pillars of Islam, 5 foundational pillars of Islam. So anybody who is a Muslim can only be going to be considered as practicing Muslim if he is going to have a belief, he or she is going to have a belief on the 5 important pillars of Islam. So there are 5 pillars of Islam. Number 1 is Tawheed. Tawheed actually means believe in Allah. Tawheed, which means believe in Allah, and the person who is a practicing Muslim, practicing Islam, must be going to be abide by the principle of Tawheed. Number 2, Roza. Number 3, Namaz. Number 4, Hajj. And number 5, very important, Zakat. Zakat means alms giving, the alms giving donation, whatever the person's yearly income is, 2.5% of it must be donated to the charitable work. So these are the 5 foundational pillars of Islam, and anybody who's considered to be the believer on the principles of Islam need to be abiding by these principles as well. So based upon the principle of Zakat itself, there is one advanced version of it, and that is Waqf over here. And as per the legend, there is a very famous legend in the Islamic studies which says so. So one Khalifa Omar, there used to be one Khalifa Omar, and he wants to donate his property. So once he wants to donate his property, he asked Prophet Muhammad sallallahu alaihi wasallam, he asked him, what should I do with my property? What should I do with my property? I want to donate it, but donate it for which particular cause? I have no idea about it. So please guide me. So Prophet Muhammad had recommended it to him that if you are donating your property, donate your property for the social welfare for the girl child, social welfare for the poor people, social welfare for the old age people. And therefore the tradition of Waqf being started. So ever since the guidance of Prophet Muhammad to right now, student, the Islamic people or the people who believe in the traditions of Islam, they have a good attachment with the Waqf itself. The problem is not with the tradition, the problem is the mismanagement of it. And in order to encounter the mismanagement, government decided to introduce certain amendments which are actually posing certain constitutional questions which we have to look into. So in a nutshell, student, Waqf is very much integrated with the Islamic traditions as being propagated by the Prophet Muhammad to right now. The Islamic traditions allow to have endowment by a person who is donating his property for some charitable or for some religious work itself. Now, at this particular stage, I can give you one more definition, which is Waqf is a permanent donation. The word permanent is very, very important. Waqf is a permanent donation, and the person who is donating it is known as Waqif. So if a person who is donating his property to the Waqf board or to the Waqf institution is going to be known as Waqif, and this is going to be a permanent donation. Permanent donation for a pious work, pious which means pure, which means pavitra, pious work, and permanent donation for some religious work, and permanent donation for some charitable work. Now the word permanent donation is very, very important, because as per Islamic tradition, if a person is donating his property for the charitable work, now let me write permanent donation of property. So if a property here means either movable or immovable, it can be anything. So if a person is donating his property for a charitable work, then the right of his property, shall be vested in God. Shall be vested in God. This is the most important line which has been primarily associated with the Waqf itself. So once the person is going to donate his property to the Waqf work or to the Waqf board or for some any charitable endowment, charitable work or for some religious work or for some pious work, the right of that particular property shall be vested in God. And since God is permanent, God is going to be always there. So once the property is going to be donated to the God, and people will come, people will go, but God is always going to be there. Therefore, this property now belongs to the God and it is going to be for God forever. So one very important point is, once the property is donated, it is going to be considered as permanent donation. So it cannot be taken back, because you cannot take back your property from God. You can come, you can go, your children will come, your children will go, but the property ownership now vested with God and it cannot be taken away. So one very important aspect of Waqf is a permanent donation, and Waqf property is inalienable. It's a very important point. Sometimes it creates a lot of hue and cry and dispute as well. Waqf property is an inalienable property. Once you are donating your property, once the Waqif is donating his property, it is going to be considered as permanent donation. Now the right of his property shall be vested in God, and God is always going to be there. God is not destructible. God is always going to be there. Therefore, property rights always now belongs to the God. You cannot take it away. And therefore, there is a concept that Waqf property is inalienable. Inalienable means it cannot be sold, it cannot be sold, it cannot be gifted to anyone, it cannot be sold, it cannot be gifted to anyone, it cannot be encumbered, मतलब इसका लीज नहीं बनेगा, इसका लीज लेके ऐसा नहीं कि ओनरशिप ट्रांसफर हो जाएगी. It cannot be sold, it cannot be gifted, it cannot be encumbered, and the most controversial point, it cannot be inherited again by the family member of Waqif. It is not going to be the case where the Waqif is donating a property and after 3 or 4 generations, the lineage of the Waqif are going to come to the court and say that this property belongs to my forefather. Now I want to get it back from the Waqf board and please donate it to me once again. That's not going to be possible, because once the property is going to be a Waqf property, it is going to be considered as permanent donation. Property belongs to the God now, and it is going to be having the inalienable property, which cannot be sold, cannot be gifted, cannot be encumbered, cannot be inherited. This is the most essential introduction aspect of the word Waqf. So if you want to introduce your answer, you can always start with this particular terminologies that I have shared with you, that Waqf is a permanent donation. It is essentially for the pious religious work and charitable work, and the property rights is going to be vested once the Waqif is donating his property for the Waqf work. Now student, this is the tradition been going on since ages in our country. As per the learnings of the medieval history, it has been written again and again that Muhammad Ghori introduced the concept of Waqf in India. And as the Islamic dynasties spread all over the India, and so does the Mughal rule, the essentiality or applicability of Waqf also spread throughout our country. And during the time of Britishers, they've introduced certain law to make sure that the Islamic community or the Muslim community are not going to get disturbed by the land laws in our country, by the civil suits in our country, under which Muslims are going to be having any problem. So, a student, to be very honest, Muhammad Ghori introduced the concept of Waqf, spread it out throughout the India. The concept of Waqf enlarged through the length and the breadth of the country, but it was the Britishers who have introduced certain laws in order to make sure that the principles of Waqf are going to be there onto the ground itself. So let's look into the second aspect, various important laws related to the Waqf property. So let's look into this area. After all, government is introducing amendment in it. So before we study the amendment, first of all, we need to look into those laws which are actually the governing principles of Waqf property in our country. Laws related to Waqf property. So the very first law related to the Waqf property is Musalman Waqf Validating Act 1913. A very important one. Musalman Waqf Validating Act 1913. And one very important point over here, one of the most important point, I guess if you are going to be very comfortable with the point that I'm going to mention it out here, then I guess 50% of the topic is going to be quite clear to you. The most important word which is actually turning out to be a bone of contention between the Muslim institution and government is this particular word. Under the Musalman Waqf Validating Act 1930, Britishers validated the practice of Waqf, where they validated a very important practice of Waqf alal aulad. It's a very important terminology. Let's put our primary focus over here. So student, before this 1913, Muslim families in our country used to practice Waqf alal aulad. So what is Waqf alal aulad? Waqf alal aulad means, let's say there is a person A and he is having, let's say, 50 acres of properties. Now he is into his old age and he believes whatever property that I am having it right now, it should be enjoyed by my future generation as well. But he is not sure whether this property is going to be there in the family or not. So he'll be going to create a Waqf. So once he'll be going to create a Waqf, but with a condition Waqf alal aulad, which means I am donating my property for the Waqf board, or I am donating my property for some endowment work, for some religious work, but there going to be one interest of this property. This property will be going to earn some amount of money for my family, and this money is going to be dedicated to the family, not only my immediate family, but my upcoming generation as well. So what this concept is, this concept says that if there is a person A, a Muslim community person A, he is donating his property to the Waqf board with a condition that this is a Waqf alal aulad property, which means जब तक मेरी आने वाली जनरेशन में मेरी लाइनेज खत्म नहीं हो जाती, विच मीन्स मेरी फ्यूचर जनरेशन में बेटे होने की कंडीशन खत्म नहीं हो जाती, जब तक मेरी सक्सेशन लाइन बनी रहती है, till the day my succession line in the family is going to be there, Waqf board or any particular institution that is taking care of my property will give certain amount of money to my family. So let's say I'm having a 50 acre of property, some amount of money shall be given to my family, to my son, and to his son, then to his son, so on and so forth. till the succession of the family continues. So in this way, the person is going to get ensured that after my death, my succession line people or my succession line persons are going to enjoy the property by taking some amount of, by every month getting some amount of money or every year getting some amount of money, so that they can continue to have a complete ownership of the property itself. Of course, it is going to be the Waqf property. It cannot be sold. It cannot be encumbered, but the family is going to have certain amount of benefit of it in every year. But the condition is, once the succession line ended, which means no son in a family, no son in a family, no male member in a family, once the succession line is going to get ended, then the property will get completely onto having the Waqf board ownership, and Waqf board will not give any single rupee on an annual basis to that particular family. Which means Waqf alal aulad is a concept that till the succession line of the family is going to be there, the family is going to enjoy certain benefit of that particular property. But once the succession line ended, the property will get sole prerogative of the Waqf board itself. The ownership will get completely belong to the Waqf board. तो जब तक मेरी फैमिली की सक्सेशन लाइन चल रही है, तब तक फैमिली को कुछ ना कुछ पैसे या बेनिफिट्स मिलते रहेंगे. And the day succession line is going to get ended, the property ownership will get completely on having the Waqf board ownership, and Waqf board is not obliged to give any money from there on. So this was the concept related to student Waqf alal aulad. So Waqf alal aulad primarily means endowment. It is definitely an endowment because the word Waqf has been associated with it. Endowment when the line of succession ended. So what is endowment? Endowment means permanent donation. So permanent donation will not take place till the succession line is going to be there, and once the succession line is going to get ended, then it is going to be considered as permanent donation or Waqf, and of course the Waqf board is going to get the complete ownership. But till the succession line of the family going on, Waqf board is obliged to give certain amount of money which can be decided on the year to year basis on to the mutual understanding of the family and the Waqf board itself. So this was the objective of Waqf alal aulad. So what is the controversy over here? The controversy is Waqf alal aulad does not identify with the inheritance right of girl child. I should rather write versus. So Waqf alal aulad is supposedly considered to be in contravention to the principle of inheritance right of woman, inheritance right of divorced woman, inheritance right of girl child, etc. The family is going to get benefit, but they are going to get the benefit till the succession line of the family is going to be there. And once the succession line ended, the divorced woman will not get anything, girl child will not get anything, inheritance right of women are going to be essentially missing over there. It's an irony because as per the Islamic tradition, Islam is considered to be the one of the first religion, Islam is considered to be one of the first religion in the world which has decided to give property rights to the one girl child in a family. If I'm not wrong, they have a tradition of dividing the properties of the family on 1/3 and 2/3 basis. The 1/3 belongs to the girl child itself. But over here, if the property is going to be having an association with the Waqf alal aulad, the family is only going to enjoy the benefit of the property till the succession line is going to be there. And once it is ended, the divorced woman, the girl child, inheritance rights of the woman member who are going to be there in the family are going to be entirely missing. And therefore, student, it's a very, very controversial concept. The Britishers validated it by the Waqf Validating Act 1913. So, what was the background? There was a particular case in the year 18 in the decade of 1880s and 1890s, I guess, where the reformist of the Islamic organization and the Britishers have put a huge question mark in front of Waqf alal Aulad, and the Privy Council decided to abolish Waqf alal Aulad, which led to a huge furor among the Muslim community. They've gone to the court and they've lost the cases. But at the same time, Britishers realize that Waqf alal Aulad is a practice and tradition of the Islamic community for the past 1,000 years. And if we are going to take it away by the stroke of a particular law, they may be going to get antagonistic against the British administration. So Britishers ने क्या किया? What did Britishers introduce? They validated Waqf alal Aulad. Therefore, the word validating is over here. So please understand a very important point. Waqf alal Aulad is a concept which was considered to be against the women's rights even during the decade of early 20th century itself. But at the same time, Britishers decided to validate it. So this was the particular act, number 1, Musalman Waqf Validating Act 1913. Number 2, law number 2. Law number 2 is Musalman Waqf Act 1923. Musalman Waqf Act 1923. And Musalman Waqf Act 1923 appointed the position of mutawwalis. It created a position of mutawwali. Mutawwali for what? Mutawwali is going to be that person who is going to be acknowledged as administrator. He is going to be acknowledged as administrator. Administrator for what? Administrator for Waqf properties. So he'll be going to act as the administrator, or I would rather say trustee. So this mutawwali is going to act as the administrator or trustee of the Waqf property to make sure Waqf properties are going to have a proper accounts, proper maintenance of record, etc. So Waqf Act 1923 created the position of mutawwalis, and mutawwalis are going to be responsible for the maintenance of property records of the Waqf, making sure if there is one family who have endowed their property to the Waqf board as a principle of Waqf alal Aulad, so they should get certain benefit of it till their succession line is going to be there. So Waqf से related जितना भी administrative work है, it is going to be the responsibility of the mutawwali. So this position was created in the year 1923. Later on, after independence, a proper Waqf Act 1954 was created, which was subsequently amended in the year 1969, 1984, 1995, 2013 as well. So Waqf Act 1954 being created, and it created a very important position known as Waqf Board. It created a position of Waqf Board in every state of our country. So at the central government level, we have a central Waqf Council, and in the state level, we have the Waqf Board. So Waqf Board are going to be there in every state. This position being created in the year 1954 under the Waqf Act itself. One more important point. This Waqf Act was amended in the year 1984, and one more important institution being created under the Waqf Act itself, which was Waqf Tribunal. And what was Waqf Tribunal? Waqf Tribunal acted as the final arbiter of Waqf dispute. If there is going to be any dispute as per the 1984 amendment of the Waqf Act 1954, one tribunal being created, one 3-member tribunal being created known as Waqf Tribunal, and their decisions are going to be final, which means they are outside the jurisdiction of the civil code. Their decision is going to be considered as final. So they have been acknowledged as the final arbiter of a Waqf dispute, which means if there is going to be any dispute related to the Waqf property, you are only going to have one court institution where you can go and you can submit your prayer over there, and that is the Waqf tribunal itself. So this institution, Waqf tribunal, been created in the year 1984, which was actually a amendment of the Waqf Act 1954 itself. So second law, Waqf Act 1923, third law, Waqf Act 1954. Number fourth, is introduced by P.V. Narasimha Rao, Waqf Act 1995. So what was Waqf Act 1995? Waqf Act 1995 gave a very broad managing power, extraordinary power. It gave certain broad managing power to the Waqf board. तो वक्फ बोर्ड के पास खूब सारा एक्स्ट्रॉर्डनरी पावर चला गया. They were enjoying a huge amount of power related to the Waqf property itself. So by the year 1995, student, Waqf board suddenly became one of the biggest ownership of land in our country. Right now 2025, if I'm not wrong, 8,72,000 property. 8,72,000 property, 8.72 lakh property are having the Waqf ownership. And many of these properties are having a dispute with the Uttar Pradesh government, with the Karnataka government, with the Maharashtra government. There is hardly any single state in our country which is not having a dispute related to the Waqf property, and those disputes are being handled in the Waqf tribunal itself. So keeping all these things in mind, student, in the year 1995, Waqf board being given more power. So more power essentially means more occupation or more occupying of the Waqf properties. But many a times those property turning out to be a dispute. Those dispute need to be addressed. And way back in the year 2006, Justice Rajendra Sachar committee been appointed, and Justice Rajendra Sachar committee categorically mentioned that right now Waqf management is having a very shoddy characteristics. They put a huge question mark on the management of Waqf properties. That Waqf properties are mismanaged in our country. And I need not to explain you what do we mean by mismanaged. You can understand in this manner. Mismanaged means Waqf board essentially turning out to be the final arbiter. Although Waqf tribunal is the final arbiter, but Waqf board being given extraordinary power. So they declare one property to be the Waqf property. Once the property is going to be declared as to be the Waqf property, you can only go to the Waqf tribunal. There is no other way out. Number one. Number two, huge amount of mismanagement. Mismanagement means if the property needs to earn certain amount of money, that money is not being utilized for the pious charitable work for the Muslim girls or for the Muslim women, and it is being utilized for some other deviating work. So Sachar committee pointed out that as far as the Waqf properties are concerned, it's one of the most important aspect of the religious traditions of the Islam. They should practice it, but at the same time, there are certain secular work related to Waqf property like financial management, administrative work, managing the accounts, maintaining the transparency, maintaining the accountability. These all are the certain secular work related to the administration of Waqf. इसका कोई ना कोई तो ओवरव्यू होना चाहिए. And Sachar committee categorically referred to one very important point, that is, right now Muslim communities are not enjoying the said benefit of the Waqf board or the Waqf property, because Waqf is having a huge property onto their hand. Apart from the defense estate and railway, they are considered to be the biggest holder of the properties, but at the same time, its benefit are not being replicated or being devoluted onto the Muslim communities. So keeping this thing in mind, Government of India introduced Waqf Amendment Act 2013. A very important Amendment Act 2013 been introduced in the year 2013 by the Manmohan Singh government by keeping in mind previous acts and by keeping in mind the recommendation of the Sachar committee. And Manmohan Singh government introduced enlarged definition of Waqf in the year 2013. So what was the important postulates regarding Waqf Amendment Act 2013? It increases, or I would rather say enlarge the definition of Waqf. It enlarge the definition of Waqf. How come it increases or enlarge the definition of Waqf? Number one, it introduced a concept of Waqf by user. This is where the dispute is. Right now, if you look into the Indian polity at this particular stage, the Indian political debates related to Waqf property itself, BJP has an argument that Waqf by user is against the principles of having property rights in our country. Especially Waqf by user is actually encroaching upon those lands which are considered to be the government land or those lands which are having some other work but unfortunately been taken away by the Waqf board. Whereas the Islamic community, the Islamic think tanks, Muslim think tanks were having a belief that Waqf by user is one of the most essential ingredient. It cannot be taken away. So what is Waqf by user? For example, please understand one very important point. Waqf properties, what all are different type of Waqf properties? For example, if there is one mosque and people from Muslim communities are actually doing Roza over there, are doing Friday namaz over there on a regular basis, let's say for the past 300 years. So let's say there is one ancient monument. So ancient monument is having a preservation under the Ancient Monument Act. Let's say there is one heritage site, there is one monument, and it is having a preservation under the Ancient Monument Act. But at the same time, the Muslim communities are practicing their Islamic tradition of offering namaz, let's say for the past 300 years. Now, since they are practicing one of the basic tenets of Islam for the past 300 years, therefore, its welfare, maintenance, property, its welfare, maintenance of that particular property need to be associated with the Waqf board itself. This is the principle of Waqf by user. तो Waqf by user का मतलब है कि अगर किसी प्रॉपर्टी पर 300 साल से इस्लामिक ट्रेडिशंस फॉलो हो रहे हैं, नमाज पढ़ी जा रही है, वहाँ पर मान लेते हैं कोई उर्स का मेला लगता है, नमाज पढ़ी जा रही है, all different type of religious activities been going on for the past 200-300 years, but there are no valid documentation related to the transfer of property. Even under this condition, under the Waqf by user, that particular piece of land will now belong to the Waqf board itself. This is the concept of Waqf by user. So any mosque, any graveyard, any mosque, any graveyard, any particular piece of land, any institution where Islamic traditions are being going on for the past so many years and there are not documental evidence for it. There are no empirical evidence, there are no documental evidence, there are no mutation record, transfer of property record. Even under this situation, since there is a belief of Muslim community people practicing their religion, and that is Islam religion, on that particular piece of land. Therefore, this piece of land, uska koi record nahi hai, lekin fir bhi it is going to be considered as Waqf property under the definition of Waqf by user. So what is Waqf by user? Waqf by user means any property which has some historical connection with Islam religion. Any property which has some historical connection with Islam religion. That property can be any mosque, any graveyard, or any piece of land. If any piece of land, mosque, graveyard has connection with the Islam religion, even though there are no documents for it, even though there are no mutation or transfer of property related document for it, still it is going to be considered as Waqf property under the definition of Waqf by user. And this is where BJP argument is very, very staunch. Their argument is that Waqf by user in principle seems to be correct, but it is turning out to be highly incorrigible behavior of Waqf board, where they are acquiring properties just by declaring it to be a Waqf by user, even though, for example, let's say one educational institution being created on a piece of land, let's say a 5-acre land, and Muslim communities Waqf board are saying that 100 years ago, 200 years ago, 50 years ago, 30 years ago, there used to be a tradition which is actually having a Islamic tradition on this land. Therefore, now this land is not the educational institution, it belongs to the Waqf board. So BJP has a very staunch argument, and that staunch argument is Waqf by user is turning out to be a weapon in the hands of the Waqf board to acquire properties even though they have no connection with the religion. And Waqf board are denying it. They are saying we are only asking for Waqf by user for those property which have some mosque connection, graveyard connection, or some religious behavior connection. We are not going in every nook and corner of the country and claiming it to be this property as the Waqf board. We have some evidence, therefore we are asking for it. But evidence are more or less spiritual, evidence are more or less philosophical, evidence are more or less having the association with the people believe rather than having any document. तो बीजेपी का कहना है कि भाई बिना डॉक्यूमेंट के आप किसी भी प्रॉपर्टी को वक्फ बाय यूजर डिक्लेयर कर रहे हो, और वक्फ बोर्ड का कहना है कि हम ऐसे डिक्लेयर नहीं कर रहे, उसके कुछ ना कुछ एनेक्डोटल एविडेंस है, उसको हम कनेक्ट कर रहे हैं. So this was been introduced by the Congress government. Congress government entrenched the concept of Waqf board by giving them a very good amount of weapon onto their hand, and that is Waqf by user. Number one. Number two, Congress government also validated the concept of Waqf alal aulad. And to be very honest, student, even there are few Muslim think tank, including very respectable, very reverable Faizan Mustafa Sir, ex-Vice Chancellor of, I guess, Nalsar in Hyderabad. Even he had written in few of his article that Waqf alal aulad concept need to be completely obliterated. It should not be there. There are so many Islamic countries in the world like Turkey, like Kuwait, like Indonesia, like Malaysia. They have already decided to discard the concept of Waqf alal aulad, but it is still been practicing in India. It need to be now get completely rid of. But in the year 2013, Congress government validated it once again. So this practice has been going on, especially after the introduction of the Britishers' law. It has been going on for the past 110 years. Now BJP has the argument कि हम वुमेन्स को राइट देना चाहते हैं, जेंडर राइट्स देना चाहते हैं, और ऐसे में हम इस कंसेप्ट को कंटिन्यू नहीं करेंगे. So in the year 2013, Congress gave the concept of Waqf by user. Government introduced the concept of Waqf alal aulad as well, continued with it. And at the same time, let me go to the next slide now. And at the same time, in the Waqf Amendment Act 2013 itself, Waqf board been made a predominantly Muslim board itself. A Muslim board itself, which means people who are from outside the Muslim religion are not being allowed under the Waqf board itself. So this was the introduction in the year 2013. One very important concept. One more important concept. In the 2013 Act, Mutawalli or the administrator of the Waqf board, they have been given the status of public servant. So if anybody who is going to be given the status of public servant, and during the course of them enjoying their power, they are definitely going to have certain immunities, and certain IPC section are not going to get imposed onto them. So more powers being given to Mutawalli, they have been given the status of public servant as well. At the same time, in the 2013 Act itself, a position of CEO being created for the Waqf board, which means every Waqf board issues related to money, issues related to the transfer of properties, issues related to the management of the properties are going to be handled by the CEO. So this CEO been acknowledged to be having the topmost position in the Waqf board itself, apart from Mutawwalis. One more important area, in the 2013 Amendment Act itself, transfer of Waqf property being made almost impossible. With the advent of amendment, and certain provisions, it became virtually impossible for any Waqf property to get transferred. So Waqf properties are not going to be get transferred, and it is going to be properly under the management of the Waqf board itself. And one more important point is, student, jurisdiction of Waqf board has been increased. Jurisdiction, Waqf board jurisdiction has been increased. So this was the introduction, or this was the important amendment introduced by the 2013 central government itself. 2013, which means the Congress government itself. During the last few stages of their work, they've introduced the Waqf Amendment Act, under which so many important provisions have been added. So these were all the important provision, student, which were being added in the year 2013. So this is the essential introduction part of the Waqf board itself. So in the past at least 40-45 minute discussion, I have shared with you, number one, definition of Waqf, principle of Waqf, how the concept of Waqf been introduced as per the traditional tenets of the Islamic belief, and later on what all important laws have been introduced under the protection of the constitution or under the protection of the statutory provision itself. तो ये सारे इंपॉर्टेंट लॉस थे जो इंट्रोड्यूस किए गए, और तब से लेकर अब तक स्टूडेंट इंडिया में वक्फ प्रॉपर्टी का मैनेजमेंट चल रहा था. वन मोर इंपॉर्टेंट पॉइंट स्टूडेंट, बिफोर आई प्रोसीड फर्दर इनटू द रीजंस or those particular reasons or those particular argument based upon which BJP decided to introduce the amendment for it. Before I proceed further, one very important point here I want to share with you. Look, under the Waqf Act, we have three important institutions which are related to the management of Waqf property. Number one, we have the Central Waqf Council. We have the Central Waqf Council, which is basically having the advisory role. So anything related to the Waqf property, they are not actually the manager of the Waqf property. They actually just give guidelines, advisory. So it's a council which is having the advisory role, and minority affairs, Central Minority Affair Minister is going to be the ex officio chairman of it. I hope you know what do we mean by ex officio chairman. Irrespective of his religion, the ex officio chairman is always going to be the Ministry of Minority Affairs. Minister of Minority Affairs in the central government is going to be the ex officio chairman of Central Waqf Council, and rest all members are going to be Muslims. This was being the foundational structure of the Waqf Act itself, कि इंडिया में एक सेंट्रल वक्फ काउंसिल होगा. देयर इज गोइंग टू बी वन सेंट्रल वक्फ काउंसिल विच इज गोइंग टू प्ले अ एडवाइजरी रोल. दे ब्रिंग डाउन देयर एडवाइजेस बाय कीपिंग ऑल द स्टेक होल्डर्स इन देयर माइंड, and they will give certain advice to the Ministry of Minority Affairs, based upon which the council is going to give its recommendation to the Waqf board, and later on it is going to get replicated onto the ground. So on the central level, we have the Central Waqf Council. Ministry of Minority Affairs is the ex officio chairman of Waqf Council itself. Rest all members are going to be Muslim. And on the state level, we have the Waqf board. On the state level, we have the Waqf board, and the Waqf board will be going to have one CEOs and we are going to have the mutawallis as well, which are basically responsible for the functionality of the Waqf board itself. This CEO need to be having the deputy secretary background itself. And third, last but not the least, is one of the most important institution, which is going to be the Waqf tribunal. And I've already described it to you. As per the 2013 Amendment Act, and of course by looking into the 1995 Act itself, Waqf Tribunal was considered to be the final arbiter of any property dispute related to Waqf board or Waqf property itself. So this was the structure been going on in our country. Let me reiterate each and everything. So from 1913 to almost student 2025 till the year 2024-2025, we used to have a very well-defined structure under which there are two important laws. Number one, Waqf Act 1995 and its amendment in the year 2013, which is actually considered to be the governing statutory principles of the Waqf board. Apart from that, we have the Central Waqf Council, Waqf Board, and of course the Waqf Tribunal, which are essentially responsible for the management of the Waqf properties and in order to handle the disputes related to the Waqf property. So based upon this structure, things were going on. But keeping in mind the Sachar committee, things were moving on, but things were not going on in the right direction. There were a lot of gray areas, there were a lot of black spots, gray areas related to the administration of Waqf property that need to be addressed. Keeping this thing in mind, student, on 8th of August 2024, government decided to bring the amendment in the Waqf Act 1995 itself. So one very important point, one very essential point. Let's look into the current aspect. Reasons for introducing Waqf Amendment Bill 2025. Although it was in the year 2024, on 8th of August 2024, Government of India introduced the Waqf Amendment Bill 2024, and later on, after the collective voice of the Parliament itself, oppositions were demanding one introspection onto the Waqf Amendment Bill, and therefore government decided to send it to a JPC. JPC did its introspection for a period of almost 6 to 7 months. And once again, the bill has been introduced in its new avatar in the month of April 2025. And after having a discussion, it has been passed from both the houses. Now the matter is sub judice. But at the same time, Waqf Amendment Bill has now been transformed into a proper act, although it has not been put forward by the Presidential Gazette. But definitely over a period of time, it is going to become the most important act in our country. But first and foremost, one very important point. अभी तक मैं आपको केवल information दे रहा था. Till now, I'm only giving you the information that what do we mean by Waqf and what do we mean by important laws related to Waqf. Now let us look into the current aspect. Going into the learnings of the documents of India, going into the learnings of the ministry, and going into the learnings introduced by various columnists and those writers in the newspaper, why Waqf board is been going through a period of transformation. What all were the reasons for introducing Waqf Amendment Bill? What all were the primary reasons? So let's look into it one by one. First of all, Government of India wants to bring more transparency, accountability. They want to bring more transparency, more accountability, and of course more probity in the functioning of, I'm writing in short form, government wants to bring more transparency, more accountability, more probity in the functioning of Waqf board in our country. And to be very honest, even Sachar committee, even Muslim institutions, Muslim think tanks are also saying that we need to have more transparency in the functionality, more regulation in the functionality of the Waqf board. Therefore, amendment was very much required. After all, please consider they are having 8,72,000 registered property onto their name. And there are so many legal disputes are also going on. And some of the disputes are been going on since the dawn of independence itself. There are some of the disputes related to the Waqf property which has been going on for the past at least 80 years itself. So keeping this thing in mind, it's very essential that we need to have a lot of transparency, accountability in the functionality of the Waqf board. So keeping this thing in mind, if government introduced the amendment, there is no problem in it. Please understand, if government introduce the amendment in the Waqf board, there is no problem in it. The problem is not in their prerogative to introduce the amendment. The problem is onto the provisions that they have added. And if you are going to look into the debates put forward by Asaduddin Owaisi, after all, he is one of the prime petitioner in front of Supreme Court in the Justice Gawai bench. More than 100 petitions been filed in the Supreme Court against the Waqf Amendment Act 2025. Initially was Waqf Amendment Bill 2024. So Supreme Court decided to club all those petitions into one petition, and the primary petition is now Asaduddin Owaisi. And you have the battery of lawyers who are defending Asaduddin Owaisi's argument. And their argument is not why the amendment has been introduced. Their argument is actually onto the provisions of various Amendment Act. So those provisions we'll be going to look into it. But first of all, let's look into the government argument. Why they've decided to introduce the amendment. So their argument is number one, more than 8,72,000 property. We need to have a proper transparency for it, proper accountability for it. We just cannot leave accountability in the hand of CEO of a Waqf board or a Mutawalli. We need to have a larger picture. Therefore, accountability, transparency, probity principles been introduced for reforming the Waqf board, and therefore it was very essential. Number two, BJP government has the argument that some irrational power has been given to Waqf board after 2013 Amendment Act. Those irrational power need to be bring into the table with a lot of rationality. We are not against Waqf board, but at the same time, we need to reform those irrational power. Irrational power means they have the power to declare any property as the Waqf property, and they always knew this thing. Once the property is going to be declared as Waqf property, the Muslim institution will try to claim it, and the other party will go to the court, and they have only one option, and that is the Waqf tribunal itself. So BJP's argument is we need to reform those irrational power. Third argument, we need to have proper auditing. We need to have proper auditing of different Waqf account. Essential, nobody can deny it, because once you are going to have a huge land balance onto your account, then under this situation, there is always going to be a case of diversion of fund or misuse of those land. Therefore, accounting and auditing need to be on a regular basis itself, and therefore government argument is definitely not incorrect over here. They want to have a proper auditing of Waqf account as well as Waqf properties. So we need to have land accounting and we need to have financial accounting as well. One more important point, student. Sachar committee has been time and again recommending it, which is administrative inefficiency are very, very high in the Waqf board. And please understand, student, from the examination perspective, you are only supposed to portray your knowledge in limited 250 words or maybe 150 words, depending upon the question's marks. But at the same time, in a very limited stipulated time and in a limited word limit manner, you are only going to portray your knowledge with having a very good vocabulary, administrative vocabulary. I always believe in order to clear the prelims exam, you need to have a good grasp on the basic definition. But in order to clear the mains exam, you need to have a good grasp onto the administrative vocabulary. Sometimes some unique word, some unique statement, some unique quote is going to fetch you even half a marks extra or 1.5 marks extra, and that is going to create the real alpha. So please use these words. And they are not against any religion. They are not against any institution. They are not very controversial. This is something Structure Committee has been time and again suggesting it to us, which is the administrative inefficiency of Waqf board is very, very high. We need to reform it. We need to reform it. So this was the fourth argument based upon which government decided to introduce the amendment bill. One more important point. Point number E is going to be this one. Inadequate representation. Waqf board are turning out to be the monopoly of few chosen people, and from one generation to another, they are having a complete command onto the Waqf board. Therefore, looking into the understanding of the Structure Committee and BJP, JPC's understanding as well, Waqf board is suffering from inadequate representation. Inadequate representation. Inadequate representation, or I would rather say inclusive representation, is not there. They are having inadequate representation and they are not having inclusive representation. They are not having inclusive representation. So ideally, a board which is for the welfare of the community itself, which is for the welfare of the community, including the girl child, including the women's, including the men's, including the old age people. So it should include people from all different type of background of the community people, and they should include certain women members, they should include some male member, they should include old age people. All stakeholders should be involved in the running of the affairs of the Waqf board itself. But unfortunately, by looking into the current structure of the Waqf board itself, they are having the inadequate representation of the women's community. They are not having inclusive representation because representation of Shia community, representation of the Bohra community, representation of the Aga Khani community. It is one of the sect of the Muslims itself. Representation of the women's are been entirely missing. So government has the argument we need to have lot of representation from the Shia community, from the Bohra community, from the Aga Khani community, from the women's community. If we are going to have representation of these communities as well, then Waqf board are definitely going to go beyond doubt, and their functionalities are going to be overall more holistic for the welfare of the Muslim community itself. So these were all the important arguments based upon which government decided to introduce one very important amendment bill. So this is the third aspect, student. So we've actually covered the third important aspect of this topic itself. One is of course definition. One is of course the laws related to the Waqf board, and the third one, what all were the primary reason based upon which the Waqf amendment bill been introduced. Now let's look into the fourth part. Fourth part is highlights of the Waqf Amendment Act. Highlights of Waqf Amendment Act 2025. Highlights of the Waqf Amendment Act 2025. One very important aspect of the highlights. Look, student, I guess many of you must be studying from me for the first time, or many of you must be watching this video from the first time. Those students who have been associated with me when I used to teach in Drashti IAS, and of course in both Hindi and English, they are very much aware about my academic pedagogy. My academic pedagogy is slightly different. Whenever I look into issue, first of all, I look into the basic definition, the historical aspect of the issue, basic definition related to the topic, and of course, if there is a particular amendment act being introduced, first of all, we'll be going to look only into the government objective. And towards the end, we will do the finishing work, and that is analysis. Most unfortunate thing that we do actually is we started doing the analysis initially. First of all, understand the definition, understand the basic tenets of the topic, then look into the government objective, then look into the bill, then look into the every factual information which is related to the topic, and then towards the end, go for the final stage, and that is the analysis. So before we move towards the analysis, before we move towards the constitutional debates of this particular act in contravention to Article 25 or 26 or not, before we get into this one, we need to look into the highlights of the Amendment Act itself. So what all are the highlights of the Amendment Act? Point number one. Government has finally decided that Central Waqf Council, by the introduction of the this act itself, that Central Waqf Council and up to certain extent the Waqf Board, Central Waqf Council and the Waqf Board, they are not religious institution, a very controversial term being introduced by the government. Central Waqf Council and Waqf Board till 2025, they've been acknowledged as the religious institution. From here onwards, they are not going to be acknowledged as the religious institution. They are going to be acknowledged as the regulatory institution. What a powerful word. Central Waqf Council and Waqf Board are no longer going to be acknowledged as a religious institution. They are rather going to be acknowledged as a regulatory institution. And since they are the regulatory institution, government can interfere, because as per Article 25 itself, if you are going to read the provision of Article 25, Article 25 says there is going to be a freedom of religion, but freedom of religion subjected to the public morality, and at the same time, in the name of a freedom of religion, if there is going to be any secular, any economic activity, then government will interfere in those activities. Please understand, we have the freedom of religion. Under the freedom of religion, let me give you one example. Under the freedom of religion, and these are the example which you can grab in any particular case law or related to the Article 25, whether it is Brahmachari versus West Bengal in the year 1995, whether it is Shirur Mutt case, whether it is related to any particular cases, you will come across this language very straightforward, which is student, number one. As per Article 25, we have the freedom of religion. So let's say under the freedom of religion, we want to practice Hindu religion in a temple. So in a temple, what are going to be the provisions of offering your prayers to the deity? Deity की prayer आप कैसे करना चाहते हो? आरती कैसे होगी? प्रसाद कैसे बटेगा? All these things are religious work, isn't it? In what manner you are going to offer your prayers? The temple timings are going to be from 7 to 9 in the morning, and then 5 to 9 in the evening. And between 9 to 5, there is not going to be any opening of the sanctum sanctorum of the temple. If all these terms and conditions are going to be there, it's the temple authority which will decide. State will not interfere, because a state will not interfere onto those matters which are related to religious propagation. But any secular activity, for example, what all donations are there in the temple, those donations need to have the overview of the state. If the temple is acquiring a 10 acre of land, those 10 acre of land should only be utilized for the welfare of the temple, not for the welfare of the individual. A state will interfere onto it. All these are the secular activities. So what do we mean by secular activity related to religion? One very important point. I hope in your polity class, you have gone through this statement. Otherwise, you may be finding it to be difficult. What do we mean by secular activity related to religion? Secular activity related to religion means something which is omnipresent, something which is omnipresent for the functionality of the administration itself. So don't you think, student, temples, law and order, temple, mosque, church, law and order is not a religious activity, it's a administrative activity. Number one. Money management of the temple, money which has been getting accrued on to the hundi, hundi मतलब जो दान दक्षिणा का रहता है टेम्पल्स में, जिसमें हम लोग दान डालते हैं. तो management of the temple's money, management of the temple finances, management of the mosque administration, all these are the secular activity. Any economic activity related to religion, any law and order activity related to religion are going to be considered not as the religious activity where a state cannot interfere. It is actually the secular activity where a state will interfere. So, state under Article 25 itself has the obligation to interfere into the religious matter if the matter is related to the welfare for all, social welfare, economic activities, etc. Now, please, I'm asking you a question to you. I guess you can do the introspection on your own. Let's say there is a mosque. Under that particular mosque, the Maulvis or the Hajis which are there in the mosque itself, they are going to offer their prayers, and of course the people who are behind them are going to follow those prayers. Can any state interfere in it? No, state cannot interfere in it. But if there is going to be law and order situation related to the mosque administration, if there is going to be some financial misprobity under this situation, if there is going to be the management of the mosque land itself, under this situation, a state will definitely going to get interfere, because under Article 25, states have been given freedom not to interfere with the religious matter, but to interfere with those matter which are having a secular prospects related to the religion. This is the language of Article 25. So, student, Waqf Council is having the advisory board. They are having the advisory board not with the related to the propagation of religion, but with the management of Waqf property. And property is basically a civil matter. And under this civil matter, the local administration may be going to get interfere. Therefore, Waqf board is not the sole prerogative of Muslim religion itself. Waqf board work is rather secular in nature. आफ्टर ऑल भाई, वक्फ बोर्ड प्रॉपर्टी का मैनेजमेंट करता है और प्रॉपर्टी के मैनेजमेंट में कुछ नॉन मुस्लिम्स भी इन्वॉल्व हो सकते हैं. प्रॉपर्टी के मैनेजमेंट में स्टेट के साथ डिस्प्यूट भी हो सकता है. In the properties management, the local district collector is also going to have the dispute with the Waqf board. Keeping this thing in mind, the central government has introduced Waqf Amendment Act 2025, and they are saying that Waqf Council is not a religious body. It's the administrative body, it's the regulatory body, and since it's the regulatory body, state will interfere. And so does the issues related to Waqf board. Now, Asaduddin Owaisi's party argument, Muslim think tank argument, they are having the argument that these councils are primarily doing the work of civil work or primarily doing the work of property management, but it is for the welfare of the Muslim community itself. They are not doing for the welfare of other community. They are solely doing their work for the Muslim community itself. So keeping this thing in mind, Muslim think tank and Muslim institution and Abhishek Manu Singhvi and Kapil Sibal, Dhawan, they all have a belief that Central Waqf Council and Waqf Board are religious institution. They should not be acknowledged or should be brought under the purview of regulatory institution. And only Supreme Court will decide, but based upon the BJP argument, they've decided to introduce an amendment in the Waqf Council parameter. तो गवर्नमेंट का मानना है ये रिलीजियस इंस्टीट्यूशन नहीं है, ये रेगुलेटरी है, और रेगुलेटरी इंस्टीट्यूशन है तो ये एक तरीके से सेकुलर वर्क करते हैं, तो इन पर हम इंटरफियर करेंगे under the benefits of Article 25 itself. So, number one, student, government decided to introduce Waqf Amendment Act by keeping in mind the objective of Central Waqf Council itself. Number two, government wants to have more social inclusion. They want to have more social inclusion, or they want to have more community participation of different sect of Muslim religion. Government of India wants to have more social inclusion in the Waqf board, more community participation in the Waqf board. Therefore, they've decided to bring the introduction of amendment in the Waqf Act 1995 and its subsequent amendment in the year 2013 itself. गवर्नमेंट चाहती है कि इंक्लूसिव पार्टिसिपेशन का कंसेप्ट होना चाहिए, कम्युनिटी पार्टिसिपेशन का कंसेप्ट होना चाहिए, जेंडर इक्वालिटी होनी चाहिए वक्फ बोर्ड में. देयर शुड बी अ प्रिंसिपल ऑफ gender equality in the Waqf board itself. Therefore, they've introduced the Amendment Act 2025 as well. So that's point number 2. Point number 3. Point number 3. Government wants to completely get rid of this concept known as Waqf by user. As per the Amendment Act 2025, Waqf by user concept has been discarded. It has been discarded now. It has been discarded. Only Supreme Court will tell whether Waqf by user was a legitimate provision or the illegitimate one. But as of now, Waqf by user with the stroke of the Amendment Act 2025 has been discarded. Government want to get rid of it. What was the government argument? Government argument is we want to have a safeguard of heritage site. गवर्नमेंट कहती है कि हम हेरिटेज साइट का प्रोटेक्शन करना चाहते हैं. फॉर एग्जाम्पल, लेट्स से देयर इज वन वेरी important mosque in our country. It can be any mosque. I do not want to name it because naming it would be slightly difficult over here. It may be going to create the confusion कि हाँ government इसको acquire करना चाहती है इस property को, तो मैं name नहीं कर रहा हूँ. Let's say there is one very important mosque in our country. It can be in any part of our country. Now, there are two things over here. Number one, that particular mosque is also a heritage site, and at the same time it is also a very important mosque for the Muslim community. So as per the work philosophy of the Waqf by user concept, although it is a heritage site, but Muslims are offering their prayers for the past so many decades, for the past so many centuries. So automatically or eventually it will become the property of the Waqf by user by looking into the textbook definition of Waqf by user itself. Now, government is having a belief that although Muslims are practicing their religion in this heritage site, it's an important mosque, it's a heritage site, but heritage site need to be given due importance. Therefore, as per Ancient Monument Act, its administration belongs to the government rather than the Waqf board. So, government is introducing a concept under which Waqf by user is no longer going to be in employment in our country. It is no longer going to be there. And government has the argument, we want to have a safeguarding of our heritage site. And at the same time, we want to streamline property management. Government wants to streamline the property management related to the Waqf board itself. So this is the third argument based upon which the Amendment Act 2025 has been introduced, and this point has been categorically been referred to it in the Amendment Act, that there is no longer going to be the Waqf by user concept. Number fourth, Muslim women now have been given more opportunity. So Muslim women's representation, I'm writing in short form, the word representation I'm writing in short form. So Muslim women representation are going to be increased in the Central Waqf Council along with that in Waqf board. पहले women representation ना के बराबर था. Till yesterday there were hardly any representation of the women in the Waqf Council and Waqf board, although there was a provision for it in the 2013 Amendment Act, but government is now categorically referring to more representation of women in the Waqf Council and the Waqf board. Number one. Number two, Muslim women are now going to be acknowledged as legal heirs of the Waqf property, which means a very controversial concept of Waqf alal aulad has now been discarded by the Amendment Act. Very important concept, student. Government has now decided that the concept of Waqf alal aulad is no longer going to be there. No longer going to be there doesn't mean the concept is going to be get completely obliterated or vanish. There is going to be a proper reform for it. The traditional practice of having Waqf alal aulad since the past 110 years is going to be get removed. It is going to get reformed, which means the Waqf alal aulad concept is going to be there, but in its reformed manner. Reformed manner means under the concept of the alal aulad itself, the Muslim communities and along with that the Waqf board, they have to give property rights, the traditional family property rights to the widow woman, to the divorced woman. So widow women of a family, divorced women of the family who were unfortunately not been acknowledged to have the legal heirs under the Waqf alal aulad, this concept has been completely reformed under the introduction of the Amendment Act by the government itself. Now, whether it is going to be acceptable to the Muslim community or not, this only time will tell. But as of now, government decided to introduce this concept. And the Muslim think tank argument is that the very definition of Waqf alal aulad is different. Why are you bringing women rights under the Waqf alal aulad? Because as per the Islamic tradition, women do enjoy 1/3 property rights, and it is completely different than Waqf alal aulad. So why we are integrating 1/3 inheritance right with the alal aulad concept? This is what the think tank argument is. उनका मानना है ये बिल्कुल अलग concept है और women को property rights 1/3 gender property rights already मिलते रहे हैं, तो इनको integrate करने की जरूरत क्या है यहाँ पर? So only Supreme Court will tell whether it is going to extend the merit or not. But as of now, government decided to bring the reform in the alal aulad concept as well. One more important point, point number 5. In the Amendment Act 2025 itself, now there are going to be more auditing of Waqf properties. There are going to be more auditing of the Waqf properties, and these more auditing are going to be introduced. These important Waqf properties are going to be introduced by the CAG appointed auditor as well. So CAG are going to appoint the auditor, and based upon those auditor, the work related to the Waqf properties are going to be very prudently going to be done by the CAG appointed auditor itself. So again, a very important point which was essential. Point number 6, other Muslim sects. Other Muslim sects like Shia community, Bohra community, they are also going to have a more say in the Waqf board. So Waqf board are going to have the amendment in its total number of members as well, and will be going to have more people who are going to be from the different sect of Muslim community itself, like the Shia community people, Bohra community people, Aga Khani community people. They are also going to be acknowledged as the member of the Waqf board as well. So again, a very important, very relevant work being introduced by the government itself. One most controversial point is, student, government decided that from now onwards in the Central Waqf Council and of course Waqf board, in the Central Waqf Council and in the Waqf board, now it will include non-Muslim members as well. Now it will include non-Muslim members as well. And this is where Muslim think tank have a major argument. They believe it is a violation of Article 26 because Article 26 is all about freedom to religious denominations. And those religious denominations will decide on their own whether they want to have a member from other community or not. After all, there are so many temples, there are so many gurudwaras where people only from one sect or one religion are allowed to become a board member for it. So why government is bringing the amendment for Central Waqf Council and Waqf Board itself, why they are bringing those people who are from the non-Muslim members. If they are bringing non-Muslim member over here, considering the work of the Waqf Board as the secular activity, then why not the same amendment for the Hindu denominations institutions as well? So this is the argument which only government can identify, and government has already put up their argument in front of the Supreme Court bench. Sooner or later we'll be going to have a judgment, and judgment may be going to address this particular point as well. A very controversial point, appointment of non-Muslim member in the Waqf Board and of course in the Waqf Council itself. Point number 8, Waqf Property Survey. Waqf Property Survey. So if there is going to be one dispute, let's say one particular piece of land, it is having some disputes related to whether it belongs to the Waqf Board or not. So earlier there used to be one survey commissioner. If there is going to be one Waqf property dispute, there is going to be a proper survey for it, and there used to be one survey commissioner. And this survey commissioner will be going to acknowledge whether it is a Waqf property or not. Now, from now onwards, after the amendment, Waqf property survey is no longer going to be by a survey commissioner. It is going to be by a state government appointed collector. And mind you, they've used the word collector, not district magistrate, because it is a matter of revenue. So collector and the rank of collector, which can be any revenue officer, it can be deputy collector as well. So collector is going to be the final arbiter. Earlier it is used to be the survey commissioner. Now it is going to be the collector. So collector from here onwards are going to be the final arbiter. He is going to be the final arbiter of deciding whether a property is a Waqf property or not. You have certain doubts related to collector having the power, you go to a Waqf tribunal. So this is the amendment being brought by the government. Now, Muslim think tank institution have the argument that collector or deputy collector, they are not neutral. They belong to the executive class, and executive class is not going to be against their political masters. So there is a 99% chance whatever message that the ruling government in the state capital is going to give a message to the collector, collector will submit his report on the basis of that alone, because most of the property that are having a Waqf property right now are basically Waqf by user. There is no proper land record for it. There is no proper mutation record for it, and collector will give a dictum, will give an order that this particular property will no longer going to be acknowledged as the Waqf property, and that decision is going to be finally prevailed. So this is again a very important point to student being introduced by the amendment. Instead of having a survey commissioner, now collector will conduct the survey of Waqf property. He will conduct the survey. And one more important point which I am going to write it over here itself is the extension of the 8th point itself, which is government properties are no longer going to be acknowledged as Waqf properties. Government properties will no longer, I'm writing in short form over here, government properties will no longer going to be acknowledged as Waqf property. What do we mean by it? For example, there is a dispute going on related to one land, whether it is a government property or whether it is a Waqf property. So ideally, going by the basic tenets of the Islam itself, once a Waqf property, always a Waqf property, because now the property belongs to land, now the property belongs to God, and you cannot snatch away the property from God as per the principles of the Waqf itself. तो ऐसा माना जाता था. तो अभी इंडिया में बहुत सारी गवर्नमेंट प्रॉपर्टीज को वक्फ प्रॉपर्टी डिक्लेयर किया जा चुका है. अब क्या होगा आफ्टर दिस अमेंडमेंट? once the property is going to be retrospectively decided as Waqf property, mind my words, once the property is going to be retrospectively decided as government property, then even though under the Waqf by user, that property was a Waqf property, but now since it has been acknowledged as government property retrospectively, from here onwards, it is no longer going to be Waqf property, it is going to be government property alone. Which means, one piece of land, 200 साल पहले कभी वो गवर्नमेंट प्रॉपर्टी हुआ करती थी. लेट्स से 150 years ago it was a government property, but let's say people from a Muslim community are having a graveyard onto that particular piece of land. If that graveyard is now been acknowledged as government property retrospectively, and that too by the collector, then this is no longer going to be Waqf property, it is going to be acknowledged as government property alone. So Waqf board has an argument, ये हमारी प्रॉपर्टी छीनने का तरीका है, क्योंकि हम ऐसी बहुत सी लैंड में काम कर रहे हैं जिनके पास हमारे पास लैंड रिकॉर्ड्स नहीं हैं, बट अंडर द प्रिंसिपल ऑफ वक्फ बाय यूजर दे आर फॉर द वेलफेयर ऑफ द मुस्लिम कम्युनिटी इटसेल्फ. एंड till 200 years ago, 150 years ago, almost every property was a government property, barring few zamindars property. So how come we can say that this property is not a government property? After all, every property is a government property. They can claim it in this manner. And therefore, Muslim think tank have an apprehension. They have the apprehension, they have the belief that this is the methodology or mechanism to grab our property, and therefore, they have submitted their application or petition or prayer in the Honorable Supreme Court. So, one very important point over here, student, is that government property is no longer going to be acknowledged as the Waqf property. Point number 10th, in the amendment, earlier decision of Waqf tribunal was considered to be the final. After all, they are considered to be being the final arbiter of deciding the dispute related to Waqf property. But now, decision of Waqf tribunal, as per the amendment, decision of Waqf tribunal now can be challenged within 90 days in High Court. So within 90 days, if anybody is having certain argument against the Waqf property itself, and they have already lost their cause in the Waqf tribunal, they can go to the High Court and they can challenge the matter. So earlier, the provision was Waqf tribunal decision is considered to be the final one. They've been acknowledged as the final arbiter. From here onwards, their decision can be challenged in the High Court, and of course, it can be challenged in the High Court within 90 days. And Waqf tribunal composition has also been changed. Its composition has also been changed. Earlier, it used to be a 3-member body. Now it is only going to be a 2-member body, where chairman is going to be a district judge or session judge. Chairman is going to be a judge which is already holding the capacity of being a district judge or a session court judge, and there is going to be 1 member. And the change is, this member need not to be an expert. Need not to be an expert in Islamic law. He need not to be an expert in Mohammedan law. He need not to be an expert in Islamic law. What was the change over here? Earlier, there was a condition that members need to be an expert in the Mohammedan law. Members need to be an expert in the Islamic law. Now, from here onwards, even if the person has having no knowledge of the Shariat Act 1937, is having no knowledge of the Mohammedan law, he still can occupy as the position of being a member of the Waqf tribunal itself. So, this was the amendment being introduced in the Amendment Act 2025. So, there are 2 important amendments, composition of tribunal being changed, and of course, their decision can be challenged in the High Court itself. One very important amendment, that is point number 11, Central Waqf Council are going to have 2 non-Muslim members. Central Waqf Council are going to have 2 non-Muslim members, number 1. Number 2, and among Muslim members, and among Muslim members, at least 2 women members should be there. I hope it is quite evident in front of you what was the perspective of bringing this amendment, because they want to go ahead with the concept of inclusive representation, more community participation, and of course gender equity principles. So under the provisions of parameters of working of Central Waqf Council, 2 non-Muslims members should be there as the board member, number 1, and among all those Muslim members, 2 women members should be there, which should be the at least 2 Muslim women member among the Muslim member itself. So this is again a very important provision being introduced by the government itself. So keeping all these amendment, student, this particular amendment act has been introduced and eventually been passed by both the houses of the parliament itself. So we have gone through everything related to Waqf Act. So whenever you study any topic, of course, since I'm teaching this particular topic, I have to dictate few terms, I have to write few terms, so eventually it will take some time. But look at the alacrity of the topic itself. The enthusiasm behind this topic is very, very high, because it's a topic which is generating good amount of debate related to Article 25 and 26, and therefore I have dedicated my time over here. So I've introduced it to you. Number 1, definition of Waqf, historical perspective of Waqf Act of the year 1913, 54, 1995, and of course 2013. Why government decided to introduce the Waqf Amendment Act, and what all are the highlights related to Waqf Amendment Act. Now let's look into the analysis. Let's look into the key analysis. This is where your examination preparation is going to get fulfilled. And please, that's how you have to proceed ahead. First of all, don't jump down towards the conclusion. First, understand the factual information, and you need to do a introspection. You need to take a deep dive onto the topic. You are now completely comfortable with the historical prospect of the Waqf Act, and of course important definitions like Waqf by user and Waqf alal aulad. Now we have to look into the key analysis, and those key analysis are going to be very essential from the examination perspective. Let's look into it. First of all, please understand that there are only 3 ways. There are only 3 ways one Waqif can create a Waqf. There are only 3 ways under which one person from the Islamic community itself can create a Waqf property. Number 1, he can create the endowment. He can create the endowment. Endowment means declaration or permanent donation of his movable and immovable property by having the in the oral method. In the oral method, he can create the endowment, or via the written method. Got it? This is the number 1 mechanism under which the property can be associated as the Waqf property itself. That is through the mechanism of the endowment itself. And of course, endowment upon the ending of succession line, isn't it? Endowment upon the ending of succession line, which primarily or essentially means Waqf alal aulad, isn't it? This is something I have already shared with you. So the first mechanism of creating the Waqf property is by having an endowment in the oral or written method, and of course by following the principle of Waqf alal aulad. Number 1. Number 2, Waqf can be created by Waqf by user. प्रॉपर्टी किसी की भी हो, लेकिन लोग यूज बहुत सालों से कर रहे हैं, कम्युनिटी यूज कर रही है, तो फिर वो वक्फ बाय यूजर बन जाएगी. So number 1, Waqf property can be with the method of endowment. Number 2, it can be Waqf by user. And apart from the Waqf by user, it can be through some other mechanism like a written deed or a property agreement or a written deed. Let me write with red marker itself. By a written conveyance deed itself. Deed for what? Deed for donation. Deed for donation by any community person. So you have the one mechanism which is Waqf by endowment, Waqf by user, and Waqf by agreement. Waqf by agreement, that the person wants to do the donation by having the agreement. What is the difference between the first and the third one? First one is basically by the person who's endowing his property, but he's endowing his property with the provision of Waqf alal औलाद, which means जब तक मेरा सक्सेशन एंड नहीं हो जाता तब तक मेरी फैमिली को बेनिफिट मिलते रहना चाहिए. जबकि थर्ड में ऐसा कुछ नहीं है. थर्ड में इट इज कंप्लीट आउटराइट डोनेशन. नीदर मी नॉर माई फैमिली मेंबर्स नॉर एनीबडी एल्स कैन एंजॉय दिस प्रॉपर्टी. नाउ दिस प्रॉपर्टी बिलोंग्स टू द वक्फ बोर्ड. दे आर द वन हु आर हैविंग द सोल प्रेरोगेटिव ऑफ मैनेजिंग दिस पर्टिकुलर प्रॉपर्टी इटसेल्फ. So Waqf can be created, student, by three ways. Number one, Waqf by user, by endowment from the Muslim community, and of course by a written deed or by a donation. And what all are the principles of Waqf? Waqf property are for the welfare of community. Welfare of community. Now, one very important major question that we need to ask over here, and the major question is the word Waqf comes under religious denomination? Very important question. I guess this is the most important question, keeping in mind the dispute related to the Waqf Amendment Act. Is Waqf, which means CWC and Waqf board. I am writing in short form. I hope you are going to grab the message. Is Waqf, and of course the provisions related to CWC and Waqf board, is Waqf a part of religious denomination? Is a part of a religious denomination, which means does it comes under the purview of religious denomination under Article 26? If it is a part of religious denomination, then under Article 26, Waqf enjoy every different type of freedom and a state cannot interfere. If they are not a part of religious denomination, then definitely state will interfere in the name of secular activity. तो एक बड़ा major question है, क्या वक्फ religious denomination का हिस्सा है? क्या वक्फ का होना मुसलमानों की सबसे बड़ी पहचान है? Is applicability of Waqf is one of the most important identity of being a Muslim? If the answer is yes, I'm not comfortable in giving you the answer because I'm not a court. I'm just a student of understanding judgment, but I'm not in a position to give you the judgment. And being the student, being the aspirant, being someone who's preparing for the exam, we need to look into from the overall perspective of having the open-end discussion. It should not be the closed-end discussion. It should be the open-end discussion. And the discussion goes like this one. Is Waqf a part of religious denomination? Is Waqf a religious denomination? If Waqf is a religious denomination, which means it is basically one of the most important aspect of being a Muslim. And since it is important aspect of Muslim, state should not interfere because we have the freedom of religion and freedom of religious denomination under Article 25 and 26 respectively. तो क्या वक्फ का होना मुसलमानों की पहचान को बनाना के लिए बहुत ज़रूरी है? अगर ऐसा है तो आर्टिकल 26 में वक्फ को आना चाहिए, और अगर वो आता है तो स्टेट को इंटरफियर नहीं करना चाहिए, और अगर स्टेट इंटरफियर नहीं कर सकता, देयरफॉर दिस पर्टिकुलर एक्ट व्हिच आई हैव ऑलरेडी शेयर्ड विथ यू टर्न आउट टू बी द अनकॉन्स्टिट्यूशनल. इट इज गोइंग टू बी अल्ट्रा वायर्स ऑफ द पार्लियामेंट ऑफ इंडिया टू क्रिएट अ लॉ व्हिच इज फॉर द मैनेजमेंट ऑफ द वक्फ प्रॉपर्टीज. सो दिस इज द इंपॉर्टेंट क्वेश्चन वी हैव टू आस्क. Waqf can be created in three manner. Waqf is for the welfare of Muslim community, but the larger question is Waqf a part of a religious denomination? Is Waqf a part of the identity of being Islamic tradition in India? Answer should be categorically yes or no. Only time will tell, only court will tell. Let's look into more debate over here. Look, student, we all are comfortable with Article 26. Isn't it? What is Article 26? Article 26 is right of religious denomination to manage their own affairs. Isn't it? Right of religious denomination to manage their own affairs. What a powerful line. Right of religious denominations to manage their own affairs. What do we mean by religious denomination? Religious denomination means various different religion and the ideologies related to those religions and the institutions related to those religion. So every religious denominations have a right to manage their own affairs. Now the question comes, what do we mean by religious denomination? So answer to this particular question who all are going to be acknowledged as a religious denomination is being given by Supreme Court in the Brahmachari versus State of Bengal, and which says religious denomination means collection of individuals, collective नहीं, collection होना चाहिए, collection of individuals. So what do we mean by religious denomination? Which means collection of individual sharing a same system of belief, same system of God. They are having a same belief altogether. So religious denomination means collection of individual sharing a same system of belief. Number one. Number two, religious denomination will have a distinctive name. And they are the collective individuals who will believe in the same set of God and same system of belief. They have a distinctive name and they have a common organization altogether. So this is what we mean by religious denomination. So under this principle, is Muslim community in India a religious denomination? Is Shia community, Muslim community, Sunni community, Aga Khani, Bohra community, are all these considered to be religious denomination? Answer is strictly yes, they all are religious denomination, because as per the definition by Brahmachari, Muslim community itself means it's a collection of individuals. Number one, they have a distinct name. After all, they have a distinct name, which means Musalman, which means Muslim community. They have a distinct name and they have a common organization. They have a common system of belief, common system of marriage, common system of adoption. Fine, everything is fine. So therefore, Muslim community is a religious denomination. Similarly, you have the Hindu denomination, Sikh denomination, etc. Now the pertinent question is, does Waqf come under Muslim denomination? It's a matter of introspection. Does Waqf come under Muslim denomination? Does Waqf have a collection of individual, distinctive name, common organization? Prima facie, they all seems to be like a religious denomination, but actually they are not. Because as per our government argument, Waqf is just a body not for the propagation of religion, but for the welfare of religion. And since the welfare of religion is by and large can be done by a lot of secular activity, for example, computer education, for example, girl education, for example, property rights, for example, building up of a school, acquiring land, creating different type of skill development program for them, they all are considered to be the welfare agenda of a religious denomination. How come welfare agenda is a part of only religious matter and not a secular matter? What a powerful line, student. We have a right of religious denomination under which every religious denomination can manage their own affairs. But if affairs are strictly religious, a state will not interfere. But if affairs are going to be highly secular in its characteristic, a state will interfere. So the argument of Government of India is very staunch, is very firm. They have the argument that Waqf work is not religious in its characteristic alone, it is highly secular in its characteristic. And I'm writing it in short form. Their work is highly secular in its characteristic as per the Government of India argument, whereas Muslim think tank do not believe so. Only court will tell, but this is the major dispute that we all have to understand, student. The right of religious denomination to manage their own affairs. In a nutshell, does Waqf board or central Waqf council comes under the ambit of Article 26 or not. If they come under the ambit of Article 26, government cannot dictate it to them that please have non-Muslim members as well. And at the same time, government cannot dictate it to them that you have to drop the provision of Waqf by user. So this is again a very important provision that we have to look into, student. So this is the key analysis. The key analysis says Waqf properties are huge in number and Waqf board are managing those property. But managing those property is a religious matter or a secular matter. Secular matter means administrative matter. To be very honest, my belief, it is a secular matter, it is an administrative matter. Therefore, government should interfere. But interference also have to have a limit. Those limits need to be acknowledged or those limits need to be respected by both Government of India as well as need to be addressed by the Honorable Supreme Court as well. So analysis number 1, student, whether Waqf is a future of religious denomination or not. If yes, then government cannot interfere. If no, then government can interfere. Analysis number 2. 4 major questions in front of Supreme Court. Four major questions in front of Supreme Court. So Supreme Court is definitely going to address the applicability of the Waqf Amendment Act 2025, but there are 4 major questions in front of them. Those questions are, number 1, I'm writing it over here. Is Waqf Amendment Act 2025 is in contravention to Waqf Act 1995? That's question number 1. Is Waqf Amendment Act 2025 is in contravention to the principle of Waqf Act 1995, because Waqf Act 1995 acknowledged the concept of Waqf by user and of course continued in the year 2013 itself. So if it is going to be the contravention of it, then of course Supreme Court is going to get completely discarded it. Number 1. Number 2, in the Waqf Amendment Act, student, in the Waqf Amendment Act 2025, a very important point has been added, and that point is Waqf can only be created by a person who is practicing Islam for the past 5 years. And Muslim institutions are having a belief, if Waqf can only be created by the person who is practicing Islam for last 5 years, don't you think it is in violation of the freedom of religion? Because there may be going to be people who are born in the Islamic tradition or in the Islamic religion itself, but they are not practicing Islam. And who is going to acknowledge whether it is practicing Islam or not? If a person wants to donate a property to the Waqf board, the first question that they are going to ask is whether you are practicing Islam for the last 5 years or not. Now the question is, what do we mean by practicing Islam, quote unquote? So this is where the problem is, student. Supreme Court need to address this particular point as well. And I'm writing it over here. As per Amendment Act, Waqf can only be created by a person practicing Islam. It's a very important point, practicing Islam. So let me write it in important inverted commas as well. As per Amendment Act, Waqf can only be created by a person practicing Islam. Is it not a violation of freedom of religion? Is it not a violation of freedom of religion? Because it may be possible that the person may not be practicing Islam and he still wants to donate his property, he still wants to create a waqf out of it. So under this situation, don't you think it's a violation of freedom of religion? That's what the Muslim institutions are having a belief, and they have challenged the Amendment Act 2025 by keeping in mind this point itself. As per Waqf Amendment Act, a person practicing Islam alone can, and for the past 5 years, can only be created by a person practicing Islam. Is it not a violation of freedom of religion? Because it may be possible that the person is from the same religion of Islam, but is not considering it to be a practicing Islam, but he still wants to give a property to the Waqf board itself. तो ऐसे में क्या होगा, फिर ऐसे में वक्फ प्रॉपर्टी क्रिएट नहीं हो पाएगी. तो ये क्रॉस क्वेश्चन है जो कि मुस्लिम इंस्टीट्यूशन ने पुट अप किया है. वन मोर इंपॉर्टेंट पॉइंट, थर्ड क्वेश्चन. द क्वेश्चन नंबर थर्ड इज अपॉइंटमेंट ऑफ मुस्लिम मेंबर्स, appointment of non-Muslim members. Appointment of non-Muslim members in Waqf board. Is it not discriminatory? Is it not discriminatory? This is the argument that Supreme Court will address. Is it not discriminatory? I'll give you one example. For example, under the Kashi Vishwanath Trust Act 1983, Kashi Vishwanath Trust Act 1983, whosoever is going to be the collector of Varanasi is eventually going to be the member of the Kashi Vishwanath Temple Trust as well, as per the Trust Act 1983. But it has been written in the Trust Act itself, if the collector is going to be Muslim, then that collector is not going to become the member of the Kashi Vishwanath Trust Act member. His subordinate or the officer next to him, who has to be a Hindu to become a member of the Kashi Temple Trust itself. So on one hand, you have one special law related to the administration of the Kashi Temple Trust, under which a Muslim district collector cannot become a member of the temple trust. Then why are you not amending that provision and you are bringing that provision over here where non-Muslims are going to be eventually become a party to the central Waqf council and the Waqf board? And what is government argument over here? Government argument is Waqf board work is highly secular, whereas temple trust work is more religious. Now, whether it is meritable or not, court will decide. But I believe this is the strongest point of the Muslim institution. They are having a very good footing onto this particular point. They are saying if other members of other community in the Gurudwara Prabandhak Committee, in the temple trust are not been allowed to become a member, then why are you creating exception for the Muslim bodies? So question number 1 and question number 2 are not the strong point of Muslim institution, but I guess this is one of the most strong point of Muslim institution. If in temple trust of Varanasi, in the Kashi Vishwanath Temple Trust, Muslim district collector or commissioner are not been allowed, only Hindu officers are going to be allowed to be a member of it, then why are you creating this discrimination for the Muslim institution, especially Waqf board and Central Waqf Council? And last but not the least, it's again a very important concept, D1. Why Waqf by user? Why Waqf by user is discarded in the Amendment Act? Why Waqf by user is discarded in the Amendment Act? So these are the, I hope you are already comfortable now with the concept of Waqf by user, which is based upon more or less related to tradition rather than depending upon the property document. And it's very difficult to submit the property document where exactly Muslims are practicing their religion for the past hundreds of years, and we hardly have any document related to it. So these are the 4 important questions being put it up in front of the Supreme Court. Number 1, is Waqf Amendment Act in contravention to the Amendment Act of 1995? As per the Amendment Act, only person who are practicing Islam for the past 5 years can donate their property for the Waqf. Is it not discriminatory? Is it not freedom of religion violation? Appointment of non-Muslims, is it not discriminatory? And why Waqf by user has been discarded in the new Amendment Act? Court will tell us the important aspect of all these four questions. I personally believe Supreme Court of India will not give the judgment in a manner under which this act is going to be declared unconstitutional. I guess the act is going to be acknowledged as the genuine act, is going to be acknowledged as the constitutional act, but at the same time there are going to be at least one or two provisions which are going to be put into the backbench itself, and one of them is going to be this one: why non-Muslim members are being given the opportunity to be a part of the Waqf board, whereas other religious institutions are not been going through the same amendment itself by the government right now. So these are all the four important questions which are going to be there itself. Now student, my last topic of this area itself, final words. Final words. Conclusion, final words. I'll be going to do the analysis over here with some more points. Number one, what will happen to scheduled tribe Muslims? Yes, we do have some Muslims community in our country which are being acknowledged as scheduled tribe itself. Now, as per the Amendment Act, scheduled tribe in the scheduled area who are living in scheduled area, their property cannot be converted into Waqf property. Their property cannot be converted into Waqf property. As per the Amendment Act of 2025, scheduled tribe property, it only use the word scheduled tribe property because scheduled tribes are definitely have certain protection under the Indian Constitution of Article 46 itself. And scheduled tribe property in the scheduled area cannot be converted into Waqf property. Prima facie, it seems absolutely correct that scheduled tribe property is for the welfare of the scheduled tribe. They cannot be taken away by any Waqf institution. But there are few people in our scheduled area itself who are having a religious denomination of being a Muslim community. Scheduled tribe is the constitutional acknowledgement, but their religious acknowledgement is being a Muslim community. And being a Muslim, they definitely have a right of Waqf, isn't it? So what will happen to them? They are from Muslim community, they want to create the Waqf, they want to create the endowment, they want to create the Waqf, but unfortunately by the act itself, since they are Muslim and they are scheduled tribe, they cannot create the Waqf because Muslim properties, if it's a scheduled tribe property, cannot be converted into Waqf. So what will happen to their religious right? So the lawyers from the Muslim community, Abhishek Manu Singhvi, and of course the likes of Abhishek Manu Singhvi, who are defending the Muslim community rights of managing their own affairs, they were having the argument, a person is first practicing his religion. And since the person is practicing his religion, they do have a fair amount of right under Article 25 and 26. Therefore, they should not be acknowledged as scheduled tribe first. They should be acknowledged as person from Islamic religion. And as per Islamic tradition, if they want to create Waqf, irrespective whether they are living in 5th or 6th schedule area, they need to be given a right to create Waqf. Whereas the Solicitor General Tushar Mehta argument was, no, we are not keeping this provision by keeping Muslim in mind. We are keeping this provision by having scheduled tribe in our mind. And scheduled tribe have a very specific property rights protection under Article 46. And therefore, we have not created this provision by keeping religion in our mind. We have created this provision by keeping protection of scheduled tribe in our mind. Therefore, this point is vindicated, whereas Muslim community lawyers believe this point is not at all essential. Only time will tell how effective is going to be this point. One more important area, perhaps the most important one. It's the most controversial area related to propagation of religion in our country, which is doctrine of essential religious practice. We need to find out the answer of doctrine of essential religious practice. under Article 25. And please understand, doctrine of essential religious practice is a very controversial term, because what is essential religious practice for you may be superstitious for some other person. And there have been hundreds of Supreme Court cases which have already created doubts related to doctrine of ERP and of course Article 25. For example, Ashok Lahiri case, जिसमें बलि की बात होती थी, जानवरों की बलि मंदिरों में चढ़ाई जाएगी, तो कुछ लोग उसे रिलीजन कहते हैं, कुछ लोग उसे सुपरस्टिशन कहते हैं. सुप्रीम कोर्ट ने उसे सुपरस्टिशन मान के बंद कर दिया. सिमिलरली यू हैव द very disputed case of Supreme Court, Ismail Faruqi case. Ismail Faruqi case. Immediately after the demolition of the Babri Masjid, petitions have been filed in the Supreme Court, which was related to the essentiality of having a mosque as the identity of Islamic religion. So, in the Ismail Faruqi case, petitioners had the argument that demolition of not the mosque took place, demolition of religious practices took place. Demolition of Babri Masjid was basically not a demolition of the mosque itself, it was basically the demolition of the religious tenets of Islam in India, and therefore at the same place mosque need to be recreated. This was the argument by the petitioner in the Ismail Faruqi case. And what was the Supreme Court judgment? Supreme Court judgment was, having a mosque is not the essential religious practice of Islam. Such a controversial judgment. Having the mosque is not the essential religious practice of Islam. Because after all, people are offering their namaz in their homes as well. They just have to identify where is the Qibla, where is the western side, where is the Qibla, and then they can offer their namaz over there. You need not to have a mosque in order to offer their prayers to the deity. And in the Ismail Faruqi case, Supreme Court had said, mosque is not the essential religious practice of Islam. And to be very honest, it was one of the most disputed judgment in the history of Supreme Court. In the history of Supreme Court, there have been many disputed judgment, and one of the disputed judgment, in fact, among the top 10 disputed judgment of all time, is the Ismail Faruqi case, where Supreme Court had said that no, mosque का होना जरूरी नहीं है, बिना मस्जिद के भी इस्लाम चल सकता है, इसलिए वहीं पर मस्जिद बनाना ये कोई argument नहीं है. That was the judgment. So where is the doubt over here? The doubt is, in India, we have so many religion, we have so many sectarian beliefs, so many religion, and all these things have not been clubbed under doctrine of essential religious practices. In the Ashok Lahiri case, it was related to the bali of the animals. It was related to the mosque in the Ismail Faruqi case. Similarly, you have the Sabrimala case. In the Sabrimala case, the temple authorities have a belief that those women who are in the age group of 12 to 15, which is considered to be a biologically the age group of being a menstruating woman, they should not be allowed to enter into the sanctum sanctorum of the Lord Ayappa temple in Sabrimala. Whereas Indian Young Lawyer Association argument was that no, it is definitely a violation of the gender rights in our country. Women can offer their prayers. Supreme Court eventually opened up the doors in Sabrimala case for women in the year 2018. But now the matter has been ended up in the Supreme Court. A judicial review petition has already been filed. And Supreme Court is going to answer the question to this particular question. What all are doctrine of essential religious practices? So, I just want to ask a question to you, whether Waqf, creation of Waqf, whether creation of Waqf is a part of ERP or not. If it is a part of ERP, a state cannot interfere. If it is not a part of ERP, a state can interfere. Because please understand, in our country, religion does not mean religion. Religion also means culture, religion also means belief, religion also means rituals, religion also means traditions, but they have to abide by the principle of doctrine of essential religious practices as well. So again, a very important argument, student, only time will tell whether ERP has been addressed properly or not. And right now, 7 major questions 7 major questions are being put forward in front of Supreme Court. I guess 9 judges bench are hearing the provisions related to the doctrine of essential religious practices. If I'm not wrong, the case name is Kantaru Rajivaru. सबरीमला का जो जजमेंट था ना, उसको चैलेंज किया गया और चैलेंज कर ये बोला गया, चैलेंज करके कहा गया कि ईआरपी है, वुमेन्स को एंटर नहीं देना सबरीमला में. Therefore, this tradition need to be maintained. Whereas other institutions are saying that no, it is a violation of the principles of gender equity and equality. Now, only time will tell whether it is right or not, and Supreme Court will look into the larger principle of the essential religious practices. Please understand, no court in this country or in anywhere of the world can decide whether it is ERP or not. There are so many traditions which we consider as to be legitimate, which we consider as to be bona fide, but at the same time, there are so many traditions which others consider it to be the belligerent display of religion. For example, I'll give you one very important example. I hope you have seen in Muharram procession, the Shias are used to have the self-flagellation onto their body, isn't it? They do the self-flagellation onto their body. खुद को कोड़े मार रहे होते हैं ना, खुद को मार रहे होते हैं, and from their back you can see the blood is coming out. So when Sunni used to see these things, जब सुन्नी देखते हैं इसको कि शिया मुसलमान they are hitting themselves, so they say this is not the Islamic tradition. This is a astaghfirullah. This is not the Islamic tradition. This need to be condemned. Whereas Shias are saying that we are mourning the martyrdom of the Hussein itself, and we are acknowledging those difficult times that Hussein had used to face in the battle of Karbala, and therefore we are doing the self-flagellation. तो हम याद कर रहे हैं हुसैन को ये flagellation करके, इसलिए हमारा ये tradition है. So for some people, self-flagellation during the Muharram procession is belligerent display of religion. And for some people, it is not a belligerent display. It is the acknowledged part of the religion itself. Now, if Supreme Court will say that this display need to be stopped, then Shia community will up in arm against the state itself. So this is where the problem is, student. Why we always have a huge amount of debate related to the Article 25 and Article 26 based upon these issues itself. So whether it is Ashok Lahiri case, whether it is Ismail Faruqi case, whether it was Ghulam Abbas case एक आया था 60s के डेकेड में. उसमें क्या हुआ था कि गवर्नमेंट सड़क बनाना चाहती थी और वो एक कब्रिस्तान से निकल रही थी. So the community says no, once a kabristan, always a kabristan. It cannot be changed. But the government says it is only about burying your loved one or dear ones after their death by devoting them once again to the land from they belong to. और जमीन तो पूरे भारत की कहीं भी बना लो कब्रिस्तान, यहीं बनाना है, यही थोड़ी ना जरूरी है. Therefore, government was saying that no land need to be acquired for the public welfare, social welfare, and as far as your graveyard is concerned, we can give you alternate land for the graveyard. You can bury your loved one or dear ones over there. And therefore, in the Ghulam Abbas case, Supreme Court said for the social welfare, a state can interfere in the matter of religion, provided they are not disturbing the religious denomination. Such a powerful judgment. So, this is again a very important point, student, that we have to look into doctrine of essential religious practices. And please, I would request you that once you are watching this video, after the culmination of this video, do search on internet importance of doctrine of essential religious practices. So, अगर ये इसको handle कर लेंगे, तो definitely ये doubt कभी generate होंगे ही नहीं जो अभी देखने को मिल रहे हैं. One more important point. Central Waqf Council and Waqf Board. Central Waqf Council and Waqf Board need to be more responsible, no doubt about that. Need to be more responsible. They need to have a lot of accountability. There is no doubt about that. They need to be more responsible, they need to have more accountability, and therefore certain amount of amendment is always recommendable as being put it up by the Such committee itself. Therefore, amendment is welcome. But the only question is whether Central Waqf Council and Waqf Board, whether they are doing the secular work. Secular work means work for the welfare of the people. And since they are doing secular work, do they come under the larger definition of state under Article 12? Because Article 12 is all about definition of the state itself. So if they do the work of welfare of people by having the property management of the Waqf itself, they are doing the secular work. So are they becoming a part of the Article 12, which is state? And if they are becoming the part of the state, then definitely I can drag them up onto the court itself, whether it is a tribunal or whether it is a high court itself. So again, a very important, very essential one, which we have to look into. One more important point, student, ये ना गवर्नमेंट को एड्रेस करना पड़ेगा, and which is a very essential one. Why outright more powers to collector? Although I would recommend don't write this point in your answer related to any Waqf question. But one of the most important analysis is why more power has been given to collector when it comes to the acknowledgement of government properties as the Waqf property or any dispute related to Waqf property. Because having collector as the final arbiter, because as per the Amendment Act 2025, Amendment Act 2025 decided to repeal the provisions of Section 40 of the Act 1995, under which collector is going to be the final authority for acknowledging property as the government property, Waqf property as the government property. और एक बार उसने डिक्लेयर कर दिया कि ये गवर्नमेंट प्रॉपर्टी है, तब तो फिर कुछ हो ही नहीं सकता. और दूसरी सबसे बड़ी बात, if any dispute is going to be there related to Waqf property, then until and unless collector is going to decide, that property will no longer going to be decided as Waqf property. So let's say there is one mosque in your city, and that mosque has been challenged by one of the person in your city itself, and the collector matter is being now onto the table of collector. So until and unless collector is going to decide whether this is a Waqf property or not, or a government property or not, the Waqf is not going to have any hold onto it. And therefore, if collector order that there is not going to be any prayer on this piece of land, there is not going to be any management of the Waqf board on this piece of land or this mosque, it has to be there. And therefore, student, Supreme Court also need to address this point, because it seems like the extraordinary power being given to the state administration officials itself, which says why outright more power to collector, and collector turning out to be the final arbiter in deciding the disputes related to Waqf property. So this is again a very important argument which we have to look into. And last but not the least, student, one of the most welcome point of the Waqf Amendment Act. As an individual, I firmly believe this is the most welcome point, which is as per the Amendment Act 2025, Waqf alal Aulad is no longer going to be there in the mechanism of the working parameter of the Waqf board, because Waqf alal Aulad was definitely against the inheritance right of women. It was definitely against the inheritance rights of women. Therefore, this need to be avoided, and finally government decided that no longer going to be Waqf alal Aulad, and inheritance right of women should be there. If Turkey, Kuwait, Saudi Arabia, UAE, Qatar, Indonesia, Malaysia, all important Islamic countries of the world, they've decided to already discard the provision of Waqf alal Aulad, then why India need to carry that away? And Faizan Mustafa wrote a very beautiful article in the Hindu newspaper in the month of April itself, where he was giving two arguments. Argument number one, he was saying that Waqf alal Aulad was the practice required during the medieval times, but as of now it should not be there. Therefore, if government is introducing a bill under which this provision is being removed, then it's a very welcome move. Number one. Number two, he was also having the argument that those property rights which have been vested upon the Waqf board as a matter of Waqf by user for the past at least 100 and 200 years. Government cannot take it away by even not giving them the principle of natural justice. जो राइट वक्फ बाय यूज़र के थ्रू वक्फ बोर्ड के पास हैं, जिसमें किसी मॉस्क को वो वक्फ प्रॉपर्टी बोल रहे हैं, भले ही वो किसी ज़माने में एक मॉन्यूमेंट रहा हो और गवर्नमेंट के हाथ में रहा हो, अब 200 साल से तो वक्फ बाय यूज़र के थ्रू पीपल आर प्रैक्टिसिंग रिलीजन ओवर देयर. दे कैनॉट बी गेट कैरिड अवे बाय द डिस्ट्रिक्ट कलेक्टर विदाउट इवन गिविंग देम द अपॉर्चुनिटी टू बी हर्ड अंडर द प्रिंसिपल ऑफ नेचुरल जस्टिस. और सबसे बड़ी बात है, जिन पेपर के कोई म्यूटेशन ही नहीं है, ट्रांसफर ऑफ प्रॉपर्टी एक्ट के पेपर नहीं है, उनको आप प्रूफ कैसे करोगे? फिर तो कलेक्टर जो बोलेगा वो एक्सेप्ट करना पड़ेगा. देयरफॉर एज पर फैजान मुस्तफ़ा सर, दिस इज़ अ वेलकम मूव बाय द सेंट्रल गवर्नमेंट, बट वक्फ बाय यूज़र, complete deletion of the concept of work by user is not a very welcome move, because it is giving a huge amount of power to the district collector itself. So keeping these things in mind, student, I guess Waqf Amendment Act 2025 is definitely going to be a very important topic from our examination perspective. Look, please understand, in our country, endowment of all faith, हर religion के, endowment of all faith are managed by the respective religion, and therefore Muslim religion is not the exception. In fact, they also need to be given opportunity to manage their own affairs. If some unconstitutional work is going on, you can address it. But we need to take a lot of confidence of the Muslim institution, and then we need to go ahead with it. And last word, student, there has to be a coordination between and cooperation between the two acts, the Waqf Act and Indian Trust Act 1882. We cannot see those two acts in silos. They are complementary to each other. The only difference is Waqf Act is related to endowment, Waqf Act, Dan, endowment, and which is only for Muslim religion. And here the Indian Trust Act 1882 is also for the endowment for charitable work, but it is slightly been open for all. It is also for charitable work and open for all. And you know what's the irony? Irony is the matter related to Waqf Act were only been heard by Waqf Tribunal. Initially, it was only been heard by Waqf Tribunal, whereas Act related to the Indian Trust Act 1882 were being heard by the civil court itself. So therefore, we need to bring them in tandem to each other. We need not to have a difference between these two acts. They all have the same purpose, and the purpose is to promote the charitable work for the social upliftment of various communities. So in this particular manner, इसके मैटर केवल ट्रिब्यूनल में चलेंगे, इसके सिविल कोर्ट में चलेंगे, और दोनों में jurisdiction अलग अलग रहेगा. ये नहीं होना चाहिए था, इनको एक मैटर में लाना चाहिए था. And it's a very welcome move that finally government has decided that both Waqf Act and the Indian Trust Act cases can finally ended up in High Court, and High Court is going to be turning out to be one of the most important institution to decide the civil suits related to the charitable work donation, or of course the endowment donation by the Muslim communities. So keeping this thing in mind, student, it's a very important provision, very important act. The most important aspect of this act of amendment by the government is the fact that they want to give property rights, women property rights or gender rights to the Muslim community. But it should not be in contravention to the religious principles itself. So both the principle of Article 25 and 26 as well as objective of gender rights need to be respected. So this is what this particular topic is all about. And to be very honest, one of the most important concept over here is we need to address the doctrine of essential religious practices first. Then only we should think about whether Waqf is only a secular activity or only a religious activity. So this is how I'll be going to proceed ahead with any topic of the Indian polity. Majorly important, controversial topic, debatable topic, where there is a lot of learning related to understanding of Indian constitutions are going to be there. This is something I'll be going to discuss in my session itself. So that's it for this session. I'll see you in next session.